I'm sitting here with my clients, and my clients have authorized me to speak on their behalf about matters dealing with the commission of war crimes and the commission of felonies by judges in the Third Circuit Court of the state of Hawaii. My clients have been deprived of a fair and regular trial, which is afforded to them under the Geneva Convention. Let me explain to you a little bit about what that means. Hawaii continues as an illegal occupied nation by the United States in violation of international and U.S. constitutional law. Because of that illegal occupation and the fact that there is no treaty of annexation, the United States does not legally exist here in the Kingdom of Hawaii. The courts, therefore, have been unlawfully constituted, and the retention of jurisdiction over matters, and in particular with my clients over matters concerning foreclosure, has been a violation of the Geneva Convention, and as well as has been the commission of felonies under U.S. law, that being Title 18, Section 2441. A little bit of background. In these cases, my clients were subject to foreclosure proceedings. And in the foreclosure proceedings, banks and their attorneys brought complaints to foreclose upon the homes of my clients. On behalf of my clients, I was retained at that time to dismiss the complaints that were filed because the courts lacked subject matter jurisdiction. In the proceedings, I filed motions on their behalf and provided the evidence to prove not only that the Kingdom of Hawaii continues to exist, but that there were also existing treaties between the Hawaiian Kingdom and the United States that the United States continued to be in violation of. Because of these existing treaties, and because of the fact that the United States has no treaty of annexations, I provided additional evidence to the courts that they could not retain jurisdiction over these matters, and that as a court they were unlawfully constituted, and their retention of jurisdiction would be in fact a violation of international law and the commission of felonies under U.S. law. What has happened is that the courts have continued to retain jurisdiction in violation of the laws. And on my clients' behalf, I was authorized to file complaints with the international courts, as well as protests and demands with the United States Pacific Command, demanding that the U.S. Pacific Command investigate the commission of these felonies, and also asking the international courts, should the Pacific Command fail in their obligation to investigate and bring these claims to justice, that the International Criminal Court steps in. I wish to provide to Mr. Corrigan a copy of the letter from the International Criminal Court in The Hague, Netherlands, and I will provide a copy of that letter to him at the conclusion of this press conference. It's dated March 4th, 2013, from the International Criminal Courts, acknowledging my receipt, their receipt, excuse me, of the complaints for war crimes that we filed against the judges and against the banks and the attorneys prosecuting or attempting to prosecute their complaints against my clients. What's significant about the acknowledgement of my complaints by the ICC is that by acknowledging receipt of these complaints and the fact that they are in fact continuing their monitoring and ultimate investigation of the complaints, the ICC has acknowledged the independent state of Hawaii. And if Hawaii was not or did not continue to be an independent nation, an independent state, the ICC could not have acknowledged the receipt of these complaints without in fact infringing on the sovereignty of the United States. So just to be clear, the International Criminal Courts have acknowledged the existence of the independent Kingdom of Hawaii, independent state of Hawaii, and that the United States has no jurisdiction over these islands. What's also important for me to disclose is that in August of 2012, the acting government for the Hawaiian Kingdom lodged a protest and demand with the United Nations calling for the end of the prolonged occupation of the Hawaiian Kingdom. Prolonged occupation of the Hawaiian Kingdom. That protest and demand was also acknowledged and received by the United Nations General Assembly and the President of the United Nations. Once again, that acknowledgement and receipt could not have been received by the United Nations if they did not, in fact, recognize the independent state of Hawaii. In December of 2012, and I believe February of 2013, the acting government also lodged with the United Nations a letter of accession to the ICC, the International Criminal Court, as well as a letter of accession to the Geneva Convention. The significance of those letters of accession, one was that it was received again, acknowledging the independence of the Hawaiian Kingdom. And two, it was at that point that the International Criminal Court was able to assert jurisdiction over these criminal complaints that have been filed by my clients, as well as recognize that my clients, in fact, are protected people, citizens under the Geneva Convention. Now, what's important for me to disclose is that after filing of these war crime complaints with both the ICC and the protests and demands with the Geneva with the U.S. Pacific Command, my clients filed criminal complaint reports with the Hawaii County Police Department and with Officer Leland Pa. Now, it's important that Officer Pa, in fact, did receive these complaints, did assign all of these complaints criminal numbers, and did begin preliminary criminal investigation into these complaints. I also wish to provide Mr. Corrigan, upon conclusion of this press conference, a letter that I provided to Detective Derek Morimoto, dated April 14, 2013. He is currently, or at last knowledge, was the current detective continuing the investigation of these criminal complaints. As a little bit of background, each of my clients on their own filed the complaints with Officer Pa, complaining that they had been deprived of a fair and regular trial in violation of the Geneva Convention and a felony under U.S. law. Officer Pa took these complaints again, assigned criminal numbers, and did the investigation. Shortly after his initial preliminary investigations, Officer Pa was placed on leave without pay. And we believe as a direct result of his taking and assigning the criminal complaint numbers to these complaints from my clients. It's significant because we believe, and my clients believe, and a main reason for holding this press conference is that actions were being taken that seems to indicate an effort to thwart the criminal investigations into these complaints. Also, by placing Officer Pa on leave without pay, administrative leave without pay, my clients also believe and felt that efforts were being made to send a clear message to any police officer who sought to take these complaints, which is their duty under law to do, but it was an effort to intimidate officers from also taking, receiving, and assigning criminal complaint numbers to these complaints. I'm happy to say that Officer Pa, of course, has gone through the administration process or is continuing his administration process, and I think he has the support of his union. I believe, and I just believe, upon information and belief, I believe Officer Pa has been reinstated. Although his administrative situation has still not yet been resolved. That is why sometime in early April, Detective Morimoto was reassigned these criminal complaints and was the person in charge with continuing the investigation. This letter to Officer Morimoto explains in depth the background and the legal basis for the criminal complaints, as I mentioned earlier, the war crimes and the commission of felonies. But it also instructs Officer Morimoto that on completion of their initial investigations, that it should be properly routed to the United States Pacific Command for the completion of that investigation and the pursuit of prosecution if necessary to bring this matter to justice. I've recently read the press release from the Hawaii County Police Department, as well as an article in the Hawaii Tribune Herald that was dated today, March 9th, about their response to my press release. I guess I am happy to say that it is being brought to the public's attention, because I think that's important. That's the first thing that's important. I think public awareness of this important issue is paramount, not only for providing the public with the proper information, what's out there, but also for the protection of my clients and their claims for the criminal complaints. I would like to address what I believe is some misstatements or some inaccuracies about the article. I believe it is Assistant Police Chief, and forgive me. Yes. What is his name? Marshal Hailua, that indicated that they were not conducting any investigation into the complaints. And in fact, what they've done is that they forwarded these complaints to the FBI. And if the FBI conducts its investigation, that's up to them. I don't know Assistant Chief Hailua, so I've never, and I haven't spoken to him. So I'm not sure what information that he is aware of or been privy to. I do believe that his statement, though, it conflicts with information that we have and statements that have been made by Detective Morimoto to some of my clients, as well as direct correspondence I have had with Detective Morimoto. And in fact, Detective Morimoto has indicated to some of my clients and myself that he was conducting an investigation at the time. Another inaccuracy I'd like to correct with the article is Kani Hailua's statement that it was forwarded to the FBI. In my letter to Detective Morimoto, dated April 14, 2013, I provided the legal basis and the instructions to Morimoto that it should properly be rerouted once the initial investigation is completed to the U.S. Pacific Command. And the reason for that is simply this. The FBI is part of the Department of Justice, and the Department of Justice's jurisdiction is limited to its territorial borders, and that is the United States. Because Hawaii is not part of the United States, the FBI should not have jurisdiction over this investigation. Because we are currently occupied by the United States, and the military is here, the proper authority to conduct and complete the investigation is the U.S. Pacific Command. And the proper authority to, in fact, not after completion of an investigation, but to prosecute the perpetrators would be also the U.S. Pacific Command's authority. Now, the letter that I sent to Detective Morimoto was also copied to the International Criminal Courts, the Geneva, the UN, the United Nations, as well as the U.S. Pacific Command. And what's important with that is that while the International Criminal Courts has jurisdiction over the commission of war crimes, they are in fact a court of last resort. So what that means is that they first will give the opportunity to the U.S. Pacific Command to conduct its proper investigation and to prosecute if the evidence proves that it should. By my notifying and keeping the ICC apprised of every step of this, every part of this investigation, what I am doing, of course, is making sure that should the Pacific Command or should any proper authority fail to complete its investigation and prosecute or bring this matter to justice, I can then invoke the jurisdiction of the ICC because of the failure of the Pacific Command to do its job. Again, it is clear Hawaii continues to be illegally occupied. The United States has usurped that occupation in violation of treaties existing between the Hawaiian Kingdom and the United States, in violation of international law, as well as in violation of the U.S.'s own Constitution. Again, what's undisputed is that there is no treaty of annexation. And what's clear is that without a treaty of annexation, any congressional enactment, including the enactment for the territory of the state of Hawaii and the enactment for the territory of Hawaii and the Statehood Act, are internal legislations that have no force and effect beyond the U.S. territory. As a result of this, again, it has been my client's position that these courts have no jurisdiction over matters concerning land. And these courts have no jurisdiction over matters concerning the prosecution of foreclosure actions. The courts that is lawfully constituted to do that is the Hawaiian Kingdom Court. But because we continue to be illegally occupied, in the meantime, it is the U.S. Pacific Command's authority and obligation to administer Hawaiian Kingdom law, and not these courts administering law under the state of Hawaii. That again is violation of international law and U.S. law. I think, and I'm sorry for making it a long statement, but I think that concludes my presentation in the press conference, and I'm happy to answer any questions you might have.
Maybe, how does Laulima fit into this? You're able to talk about that?
As CEO and president of Laulima Title Search and Claims, our clients comes into play as a result of coming to us initially because we primarily are able to show that there is a defect in title. And all property here in Hawaii, whether it's residential or commercial, have a defect in title. So when they first come to us, we're able to show that there's defects in the titles. So we're able to provide all this documentation so that we can take it to the banks to show that our clients had title insurance in order for the banks to file a title insurance claim to pay off that debt instead of foreclosing on our clients' property. But instead of doing that, and this is all contractual, this is all contracts and so forth, and we're able to do that, and we're able to show the evidence because we have all the experts to provide all the proof and so forth. And the banks have denied this evidence and are breaching the contract, and it shows that in the mortgage agreements. And they breached the contract and instead are taking our clients to court and filing a foreclosure agreement. And we're providing that evidence to the judges, and the judges are also ignoring the fact that the banks have breached their own contracts. Okay, and it's very simple. And the judges don't have to be in this situation, and neither do our clients. All the judges have got to do is tell the banks to follow your contracts with our clients and enforce that mortgage agreement and follow along and use the title insurance, because in those provisions they have one of two things that they can either do: either to quiet title the property or file a title insurance claim if there is a defect in title, and we've got all the evidence. And so they decide to do the latter because they're afraid that if they file the title insurance claims, title insurance carriers throughout America are going to pull out of Hawaii. And if they pull out of Hawaii, the banks will no longer be able to make any more real estate loans in Hawaii. So instead, they would rather foreclose on the client's properties. It just doesn't make any sense. So as a result of that, the banks are foreclosing, and so this is why we're having to take it to litigation, on this. And now we're able to provide a huge amount of evidence to the courts. The courts are accepting judicial notice as irrefutable with all the evidence we're providing, but the judges are still saying that they still have jurisdiction over all these matters with no treaty of annexation that we're showing, the executive agreements of Queen Liliuokalani, and that the Kingdom of Hawaii continues to exist, and that the judges really don't have any jurisdiction. And after accepting all this evidence, the judges say, oh, I still have jurisdiction, and providing an unfair trial and a miscarriage of justice to our clients. And so this is the dilemma that's taking place, not only to the clients, but also myself as a victim, to all of this. So it could be easily remedied, and the judges don't have to be in a situation where they're being charged with a war crime if they only did the right thing. The problem that we also have is that the attorneys for the banks have not been able to refute or provide any evidence to prove that there is a treaty of annexation. They can't prove it. They haven't been able to refute the executive agreements. All of the evidence, they've never been able to refute any of the evidence. And this is why now the banks, as well as the attorneys, are now being charged with war crimes also. When you see all this stuff and what's taking place in the courts, it's just crazy. It's just crazy. And I'm really happy that, Attorney Dexter Kaiama is able to represent, the clients and myself, and to take this on, take the clients on and myself, because it's very, very unfair that what has taken place.
Good. Dave, if I may make a point of clarification, I'm glad Cully did bring up some very important points. While I actually think the Laulima claims and the title insurance issue has a solid foundation, and I think an undisputable one, I don't represent Laulima Title as the attorney, and I don't actually. I am not.
Right.
I am not representing them on the title issue claims. My representation of the clients is based on the fact that the courts lack the subject matter jurisdiction, and in fact, their decision to retain jurisdiction is a violation of international and U.S. criminal law. But it just so happens that many of the Laulima clients are the ones that contacted me asking me to represent them in these foreclosure proceedings. So I did that when they did retain me. What's also important about the illegal retention of jurisdiction by these unlawfully constituted courts is that it does not necessarily only apply to matters concerning foreclosure. It actually applies, these arguments apply, or this legal position applies to any matter in which the court seeks to retain jurisdiction under state law, because it does not exist. So it does apply. I've actually made arguments on behalf of clients in traffic matters, on tax matters. So the concept of the violation applies through all courts attempting to retain jurisdiction under U.S. Hawaii state law.
Have you represented clients for the license plates? Have you done that?
Actually not, but I actually have a client. I did have a client who recently retained me for that very issue.
Yeah.
So those are other issues that I'll be addressing as well. So, and there was one other issue. What Cully talked about as far as the criminal complaints being brought not only against the judges but against the attorneys representing the banks as well as the banks themselves. Because what they're doing, of course, by their pursuing the complaints and invoking Hawaii state law, they are in fact also putting my clients in a position where they're being denied a fair and regular trial. Now, the concept of a fair and regular trial being a war crime and the commission of a felony is pursuant to Article 147 of the Geneva Convention, Section 4, which was signed by all contracting parties, including the United States in 1949. Now, the Geneva Convention 4 actually provides a whole list of violations that actually constitutes a war crime. Under Article 147, the deprivation of a fair and regular trial is a war crime under the Geneva Convention. Now, the United States, as a contracting party to the Geneva Convention, was also obligated to create its own law for the for the violation of war crimes occurring within the United States. So in 1996, the United States enacted the War Crimes Act, and that is Title 18, Section 244, which makes the deprivation of a fair and regular trial under the Geneva Convention also the commission of a felony under U.S. law. So that is the criminal complaint that my clients have filed with the police department, alleging not only violations of Geneva Convention, but also the commission of a felony under Title 18, Section 2441. And one final statement, some of the banks, including one of the banks I think being Deutsche Bank International, is in fact a foreign corporation. On behalf of my clients, what I've recently done is I've apprised the Attorney General for Germany that Deutsche Bank is also engaging in the commission of a felony under German law, because they also have a similar statute to the U.S. law under Section 2441. And I've asked the Attorney General for Germany to start their investigation with respect to Deutsche Bank. So if there are other banks as well that are foreign national banks that are engaging in this illegal practice, upon the authorization and instruction of my clients, I will also apprise the appropriate authorities for each nation state of the commission of that crime. Thank you. Any other questions?
I guess you probably agree, personally as well as globally, there's a lot at stake for this sort of thing. Yes, that is correct. Now, again, all the information I've provided to the courts and all the evidence I've provided to the courts is evidence well-founded in law, is facts that are undisputed, and it's important to note that I've now appeared before the courts not only in the Third Circuit but in all circuits of under the current state of Hawaii, and I've made these same arguments, and I've also apprised the judges and notified the judges of their potential violations, and not in one case has either the court or the attorneys representing the bank been able to dispute the evidence that we've provided to the courts. So I think our position is clear. I think our position is undisputed. It is just now a matter of having the appropriate authorities conduct and complete their investigation into these matters. One thing comes to mind, there was a transcript of it's almost like an affidavit or something with Hilo and Kona.
That is correct.
Do you know when that was taken in the timeline?
One moment. I would be able to answer that question about the approximate date. I may be, because I think it is also included in the report that I provided to Detective Morimoto that I'd be happy to give you a copy of. In fact, it looks like on November 8th of 2012, Officer Leland Pa contacted U.S. Advocate General, I forget his name, I think it's Jeffrey Winfrey. So he is, of course, the military attorney for the Pacific Command. And he engaged in conversation, and what's significant about that conversation is Advocate General Winfrey conceded and admitted that there is no treaty of annexation. And because there is no treaty of annexation, Officer Pa and Advocate General Winfrey had additional conversations which touched upon Officer Pa's duty as a police officer to be in compliance with international law, and whether the enforcement of writs of possession ordered by the Third Circuit courts or any circuit court that's unlawfully constituted, and whether the enforcement of those illegal orders would place either sheriff's departments or police officers in jeopardy of violating international law as well. And as a result of that conversation with Advocate General Winfrey, Officer Pa reported that conversation up his chain of command and requested that his chain of command provide him proper training in the handling of these matters. So.
And was that perhaps when he was put on leave, or you know when that?
No,
Okay.
I can tell you the criminal complaints were initiated sometime near the end of February of this year. And Officer Pa made his made his first inquiries and initial contacts with the alleged perpetrators, I believe sometime on February 28th of this year. And then he was placed on administrative leave without pay the following day on March 1st. So it's somewhere within that timetable. So as soon as he began his initial preliminary investigations, the following day he was placed on administrative leave without pay.
I
So
don't know how much you could say or what kind of privileges there might be, but is that an assumption you're making that his administrative leave was a result, or has it been indicated to you that it was a result of his investigation?
I've actually, and I don't know whether you would have to speak with Officer Pa or his union representative, but I did receive from Officer Pa the official complaints against him, placing him on leave official leave with administrative pay. And the official complaints provided detailed information or complaints that were made against him from February 28th, all of the complaints that were made with him within less than a 24-hour period, and then he was placed on administrative leave without pay.
Is that sort of like an automatic thing? If you get X amount of complaints against you, regardless if they have merit, you get automatic leave, you know?
That question I cannot answer for you. Yes,
fine.
thank you.
All right.
Any other questions?
Does any of the anyone else want to speak about this? I mean, you probably might not want to talk about the exact specifics of the legal, but maybe just personally how
Sure.
all this is affecting you. If whoever would.
Yeah.
Maybe move that microphone just a little closer to the edge.
This is until I met Laulima, Kale and Dexter, and I was kind of clueless as to the history of Hawaii, and you know, I went about this trying to save my home, and I came out of this with more knowledge than I expected, and I'm comfortable with the fact that I know my evidence is all in order. Dexter does a good job in court, and it's amazing to see. It's amazing to see the judges, how they act in court, and what would be the term for that? You know, it's to see the injustices firsthand. It's pretty crazy, and I've had like several dealings in the court in the last few years, and it's the same. They just disregard the evidence, and they give the wins to the bank, and total disregard for our basic rights. And so I'm behind Dexter. I'm behind Laulima Kale, and yeah, I've gotten to know a lot of this, a lot of the law, a lot of the happenings, what's going on, the overthrow, why we're at where we're at. So I'm comfortable with my understanding of things. I think it's just time that citizens of Hawaii they get to know the same knowledge I have. So this has to spread. This has to spread fast.
Are you a resident of Puna? Or?
I'm a resident of Puna.
Yeah.
Correct.
And how are you doing? Are you a place to stay?
Yeah. I'm still in my house, and you know, it's a struggle. It's hard. It's emotional. It's an emotional roller coaster. But you know, because of my evidence, I'm more confident at night before I go to sleep, knowing that yeah, I'm right. You know, if they do come and knock on my doors and they want to do an illegal eviction, that's on them. You know, I got a lot of I've gotten over the whole being afraid of the government, so it's not a matter of being afraid anymore. It's a matter of knowing what's right, what's wrong, and teaching my kids. So, but I'm still in my house. Laulima is constant contact with me, and I've developed a good relationship with Kale and also Dexter. So it's ongoing. It's not stopping. This is a roller coaster that we're all on. So.
Mr. Corrigan, what's important to remember is that not only are these clients the victims because the crimes were perpetrated against them, but they were in court when their motions were denied, and they saw the court continue to retain jurisdiction over their case and issue unlawful orders. So they also are witnesses
to the perpetration of those crimes. So I think that's why it was also important that we hold this press conference, because it is their intent and their interest and their desire to make sure that that they're protected. And we believe the best way to give them that protection is to provide this public dissemination of information.